Welcome back. This unit, we're going to be talking about the Supreme Court. And we're going to be talking about, for our text, Alexander Hamilton's essay number 63 in the text on page 354, Defending the Judiciary. What Hamilton is writing about is the third branch, the Supreme Court. And this essay is organized to the effect of how do we appoint members of the Supreme Court, or how do we appoint judges? What is their tenure once they are appointed? And what is their role between the different branches of government? Alexander Hamilton is a very interesting guy. He is an autodidactic, meaning that he is a self-taught person, even though he did get his law degree from what is now today Columbia University. He served on Washington's staff and had Washington's confidence to such a great extent that he made decisions independent of Washington. And while being on Washington's staff, Hamilton had the idea of studying political economy. And one main question that he asked was, how did England, a fairly small island country, how did England become such the dominant power of the world during his lifetime? And his conclusion was, it was because of the Bank of England. Without the Bank of England, England would not have had an empire. Without the Bank of England, England would not have had the resources to create what today we think of as we think of the British Empire. Very interesting, a very interesting conclusion, because most people at the time were not thinking in those kind of terms. So in this period of his life, when he is defending ratification of the Constitution, he's writing the Federalist Papers, and he's writing them primarily with Alexander Hamilton, of course, John Jay, and Madison. As we talked about before, Hamilton becomes Secretary of the Treasury under George Washington, and Madison becomes Secretary of State under President Jefferson. Madison is the leading anti-federalist, or one of the leading anti-federalists, and then Hamilton is one of the leading federalists. But this was before that. And this is, again, they're concerned about this idea of ratifying the Constitution. When we think about judges, one of the primary aspects of being a judge is independence, is what they call political independence. And so what's very interesting is, and for our everyday lives, we can think about who do we want as a judge, or who do we want as an umpire? Do you want to have a referee with the power of the NFL or Major League Baseball? Or do you want to have a referee that has the power of professional wrestling? Now again, I don't want to offend any fans of professional wrestling, but we know that it's scripted, and we also know usually what happens is when the bad guy wants to make his move against the good guy, the referee is usually hit or knocked out. And again, try to do that in the NFL or try to do that in Major League Baseball. If you touch the referee or the umpire, you're out. And so the question remains, what kind of judge do you want? Do you want a judge that is in bed or scripted, or do you want one who will use his legal analysis and a sense of justice? Hamilton, of course, is arguing for the latter. Hamilton is talking in terms of this idea of lifetime appointment. How do you give and how do you make a person independent? Well, one of the ways that you can make a person independent is not have them be afraid of their actions, that they'll lose their job. One of the things about being a tenured professor is that tenure is supposed to protect you from exploring unpopular ideas in your research primarily, but that's basically what tenure is about. The same is true with judges. If you give them a lifetime appointment, then they do not have to be afraid of the politics that are surrounding them. We'll talk about this later when we talk about the civil rights movement. But one of the things that Dr. King understood was that it is the federal courts It was the federal courts that held the key to getting rid of segregation in the South. Dr. King never violated a federal court order, never violated a federal law. That's something to remember. It was the judges in the South who did not have to worry about being elected to anything that enabled the law to help get rid of segregation. Remember, harking back to Thurgood Marshall's speech. It was the law that enslaved, it was the law that emancipated, it was the law that segregated, and it would be the law that will give us equality. So again, on page 354, we have Hamilton's talking about this idea of the appointment of judges. The manner of constituting it seems to embrace these several objects. First, the mode of appointing judges. Second, the tenure by which they are to hold their places. And third, the partition of the judiciary authority between different courts and their relations to each other. And then he goes on. First, the appointment of judges is the same as with the appointing of other general officers in the United States. So we know this process, and this process is the president has the power to appoint, and the Senate advises and consents. Again, you may remember the appointment of Justice Kavanaugh, pardon me. And so a lot of times it's the Senate that is the place where these, especially in the Supreme Court, where these things get discussed and debated. Second, as to the tenure by which the judges are hold their places, this chiefly concerns their duration in office, the provisions for their support, and the precautions for their responsibility. Again, he quotes the Constitution. All judges who may be appointed by the United States are to hold their office during good behavior, which is conformable to the most approved of the Senate constitutions, and among the rest to that of this state. Its propriety having been drawn into question by the adversaries of that plan is no light symptom for the rage for objection, which disorders their imagination and judgment. The standard of good behavior for the continuance in office of the judicial magistrate is certainly one of the most valuable of the modern improvements in the practice of government. In a monarchy, it is an excellent barrier to the deposition of the prince. In a republic, it is no less excellent barrier to the encroachments and impressions of the representative body. And it is the best expedient which can be devised in any government to secure a steady, upright, and impartial administration of the laws. You want to have someone who is not afraid to go against the political winds, to be unpopular. Think about that, right? Think about that. And I think my referee analogy between wrestling, professional wrestling, and other sports is quite apt. So the appointment is by the constitutional procedures we talked about, and once a judge has that appointment, then they serve for life unless they get convicted of a crime, and they may be impeached. And we talked about impeachment when we talked about the Constitution. He goes on in talking about this interaction amongst the branches of government. In a government in which they are separated from each other, the judiciary, from the nature of its function, will always be the least dangerous to the political rights of the Constitution, because it will at least in a capacity to annoy or injure them. The executive not only dispenses the honors, but holds the sword of the community. The legislature not only commands the purse, but prescribes the rules by which the duties and the rights of every citizen are to be regulated. The judiciary, on the contrary, has no influence over either the sword or the purse, no direction either of the strength or of the wealth of the society. and can take no active resolution whatsoever. It may be truly said to have neither force nor will, but merely judgment, and must ultimately depend upon the aid of the execution of arm, even for the efficacy of its judgments. And this has happened in our society. There have been times that the Supreme Court has given a judgment and the president has not enforced it. And it usually has led to tragedy. One famous example of that is the Native American tribes brought cases during the Jackson administration, and the Supreme Court, Chief Justice Marshall, near the end of his life, near the end of his term, said that the U.S. was violating its treaties with the Native American people. And Jackson said, that's his opinion, let him enforce it. And we had the Trail of Tears. Again, the Supreme Court does not have the power to enforce. That's the president's job. The president is the chief law enforcement officer of our country. So the question goes back. So what kind of people do you want to have serving in the courts? If they can only make a judgment and they have no way to enforce that. This simple view of the matter suggests several important consequences. It proves incontestably that the judiciary is beyond comparison the weakest of the three departments of power, that it can never attack with success either of the other two, and that all possible care is requisite to enable it to defend itself against their attacks. It equally proves that through individual oppression may now and then proceeded from the courts of justice, the general liberty of people can never be endangered from that quarter. I mean, so long as the judiciary remains truly distinct from both the legislature and the executive. For I agree, there is no liberty if the power of judging be not separated from the legislative and executive branches. It proves, in the last place, that as liberty can have nothing to fear from the judiciary alone, but would have everything to fear from its union with either other departments, that as all the effects of such a union must ensue from the dependence of the former on the latter. So, remember, the Founding Fathers, one of their real major concerns is the formation of a tyranny, right? A tyrant. And so, again, what Hamilton is trying to argue is the judiciary will be the referee, and this referee will protect liberties if it's independent. Now, if you have Supreme Court justices who are not independent, who are part of a political apparatus, then that causes a huge problem. So you hear many people in the media talk in terms of a conservative judge or a liberal judge. And this really is not an accurate label. Judges tend to be of different schools and different thoughts using legal analysis. And the two main schools of that analysis is original jurisdiction original intent. Meaning that these judges look at the text of the document, right? So if it says no religious establishment, then those judges would look at that, oh, the First Amendment, you cannot have any U.S. church. You cannot have, right, a government-sanctioned church. The other school of thought is the Constitution as a living document. And this, again, goes to the point where the Founding Fathers, the main technology that they experienced in their lives was, bleeding people and horse and buggy kind of thing. And as we progress through technology, we have to interpret the Constitution, meaning the Supreme Court. These are the two sort of essences of legal analysis. And as I assign those two videos on how to think like a lawyer, I was trying to do that. The objective of those things was to show you how thinking in the legal sense is different than from a political sense. This essay also is important because it talks in terms of judicial review before Marbury versus Madison. On page 356, the complete independence of the courts of justice is peculiarly essential in a limited constitution. By a limited constitution, I understand one which contains certain specified exceptions to the legislative authority, such, for instances, as that shall pass no bills of attainder, no ex post facto laws, and the like. Limitations of this kind can be preserved in practice no other way than through the medium of courts of justice, whose duty it must be to declare all acts contrary to the manifest tenor of the constitutional. They must make it void. Without this, all the reservations of particular rights and privileges would amount to nothing. Who says what the Constitution says? Right? Who says? And that's what we're trying to show, that it is the Supreme Court that interprets the Constitution for us. Now, Marshall, later on, as part of Marbury versus Madison, Marshall makes this part of precedent, makes it part of law. Right now, Hamilton is talking in terms of it being a political ideal. But it is one of those things that really enhances our system. He goes on, there is no position which depends on clearer principles than that every act of the delegated authority, contrary to the tenor of the commission under which it is exercised, is void. No legislative act, therefore, contrary to the Constitution can be valid. To deny this would be to affirm that the deputy is greater than the principal, that the servant is above his master, and that the representatives of the people are superior to the people themselves, that men acting by virtue of powers may do not only what their powers do not authorize, but what they forbid. Again, are we a nation of the rule of law, or are we a nation of the passions of people? If it be said that the legislative body are themselves the constitutional judges of their own powers, and that the construction they put upon them is conclusive upon the other departments, it may be answered that this cannot be a natural presumption, where it is not to be collected from any particular provisions in the Constitution. It is not otherwise to be supposed that the Constitution could intend to enable the representatives of the people to substitute their will to that of their constituents. It is far more rational to suppose that the courts were designed to be the intermediate body between the people and the legislature. And when you read Marbury versus Madison, this language is very, very familiar. This language is what what Chief Justice Marshall used. George Marshall was his distant relative, but he was a general in World War II. It is not otherwise to be supposed that the Constitution could intend to enable the representatives of the people to substitute their will to that of their constituents. It is far more rational to suppose that the courts were designed to be an intermediate body between the people and the legislature, in order, among other things, to keep the latter within the limits assigned to their authority. Remember the old saying, power corrupts and absolute power corrupts absolutely. Who is to say what is Congress doing? Is it legal or illegal? Who is to say what the president is doing? Is it legal or illegal? The interpretation of the laws is the proper and peculiar province of the courts. A constitution is, in fact, and must be regarded by the judges as a fundamental law. What he's saying there is the Constitution is the supreme law. In our text, that we know the Constitution says it is the supreme law of the land. It therefore belongs to them to ascertain its meaning, as well as the meaning of any particular act proceeding from the legislative body. If there should happen to be an irreconcilable variance between the two, that which has a superior obligation and validity ought, of course, to be preferred. Or in other words, the Constitution ought to be preferred to the statute, the intention of the people to the intention of their agents. So again, popular sovereignty, the people. The Constitution, rule of law, gives more fundamental truth than their agents, than the people who say they are working for the people, the statutes that are underneath the Constitution. So now he moves on. So we have this idea of political independence, and we have this idea of judicial review, and he moves on to this idea of what type of person do we want as a judge? And he's not talking about race or gender or these other things. He is talking about what skills do you need and what kind of traits should you have. So your skills, we'd want, I hope we'd want, that a judge would be an extremely excellent lawyer. We don't want someone who is an incompetent lawyer, right? We don't want a person who barely knows the law, even though there is no strict requirement that a justice must be a lawyer. Matter of fact, Abraham Lincoln did not appoint all his justices as lawyers. But in the modern era, we basically want to have a person who the American Bar Association or other legal organizations has certified as being qualified to be a judge. This exercise of judicial discretion in determining between two contradictory laws is exemplified in a familiar instance. It not uncommonly happens that there are two statutes existing at one time, clashing in the whole or in part of each other, and neither of them containing any repealing clause or expression. In such a case, it is the province of the courts to liquidate and fix their meaning and operation. It can be of no weight to say that the courts, on the pretense of the repugnancy, may substitute their own pleasure to the constitutional intentions of the legislature. This might as well happen in the case of two contradictory statutes. What he's saying there is, when we have two different statutes, they both seem to be the same weight. What kind of person do we want to make these decisions? If then the courts of justice are to be considered as the bulwarks of the limited Constitution against legislative encroachments, this consideration will afford a strong argument for the permanent tenure of judicial offices, since nothing will contribute to as much as this as to the independent spirit in the judges, which must be essential to the faithful performance of so arduous a duty. This independence of judges is equally requisite to stand guard the Constitution, the rights of the individual, from the effects of those ill humors, which the arts of designing men, or the influence of particular conjectures, sometimes disseminate among the people themselves, in which, though they speedily give their place to better information and more deliberate reflection, have a tendency in the meantime to occasion dangerous innovations in the government and serious oppressions of the minor party in the community. Oppression. Rules that are not part of the Constitution, or rules or laws that are unconstitutional. These can happen. These things can, as we know in our history, these things can be formed. And when later generations reflect on them, Hamilton's saying, wouldn't it be nice if we have judges that step in? Wouldn't it be nice if we have independent judges saying, I'm sorry, Mr. President, I'm sorry, Congress, this law is unconstitutional because it violates our Constitution. We need a referee. We need an independent referee. Yet, there is yet further and a weightier reason for the permanency of the judicial offices, which is deducible from the nature of the qualifications they require. It has been frequently remarked with great propriety that a voluminous code of law is one of the inconveniences necessarily connected with the advantages of a free government. If you have a free government, the thing that makes people comply is law. To avoid an arbitrary discretion in the courts, it is indispensable that they should be bound down by strict rules and precedents, which serve to define and point out their duty in every particular case that comes before them. And it will readily be conceived from the variety of controversies which grow out of the folly and wickedness of mankind that those records of those precedents must unavoidably swell to a very considerable bulk and must demand long and laborious study to acquire a competent knowledge of them. Again, why is law school 3 years? Why do people continuously have to go for something called continuing legal credit or education? Because the laws change. So he's saying what we need, first of all, are judges who know the law. Hence, it is that there can be but few men in society who will have the sufficient skill in the laws to qualify them for the stations of judges, right? So now the problem we have today in America is that all of the justices come from 2 law schools, Harvard and Yale. Now there's some very, very good law schools in the country, and people talk about diversity, which of course is important, but also there should be a diversity of training, a diversity of perspective. So we used to have people from different universities and different law schools, and today it's predominantly two different law schools. And even that small little campus on the West Coast called Stanford University doesn't have any Supreme Court justices. So again, yes, we want to have judges who understand the law and who are excellent lawyers. And making the proper deductions for the ordinary depravity of human nature, the number must still be smaller of those who unite the requisite integrity with the requisite knowledge. We want to have people who have an innate sense of justice. We want to have people of good character who are judges. So, right, he's taking this idea of, if we want to do a Venn diagram, he's taking this idea of all of us in society, right? And we have people who are lawyers, and then you have good people, and that intersection between good people and lawyers is pretty small. And I'm not making a lawyer joke, right? If I take any profession and say, we need to have people who are experts in that profession and also who are good character, that might be a very, very small number. These considerations apprise us that the government can have no great option between fit character and that a temporary duration in office, which would naturally discourage such characters from quitting a lucrative line of practice to accept a seat on the bench. This, again, is a very, very big problem for today's judicial system. A judge makes the equivalent amount of money, about $170,000 as a person in the cabinet or in Congress. And if you have some friends who are in law school or who are learning to be patent lawyers or other types of law, you know that they may start off and be hired right out of law school with about that amount of money. Many times, the least paid person in the courtroom is the judge, even in the Supreme Court. Very, 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 very dangerous, or very, very a big sacrifice by many of the people who serve on the bench. Again, think of it was your spouse, right? And you come home and say, "Hi, honey, I'm going to be appointed the judge." And your spouse says, "Well, that's great. How much does it pay?" And then their jaw drops. Would have to have a tendency to throw the administration of justice into the hands of less able and less qualified to conduct it with utility and dignity. In the present circumstances of this country and those in which it is likely to be for a long time to come, the disadvantages of this score would be greater than they may at first sight appear, but it must be confessed that they are far inferior to those which present themselves under the other aspects of the subject. What he's saying is, if you have lifetime appointment, at least you can give that judge a sense of independence, and at least you can give that judge an argument of accepting the position to his loved ones that, well, I'm not getting paid that much maybe, or I'm taking a pay cut, but I will have this job for the rest of my life. Hamilton goes on, upon the whole, there could be no room to doubt that the convention acted wisely in copying from the methods of those constitutions which have established good behavior as the tenure for their judicial offices. In point of duration, and that so far from being blamable on this account, their plan would have been inexcusably defective if it had wanted this important feature of good government. The experience of Great Britain affords an illustrious comment on the excellence of the institution. So what Hamilton is saying is, we are going to borrow from the British example, an example that they all lived with most of their lives, and we're going to give judges this idea of lifetime appointment. Because what do we want? We want to have political independence of the judiciary. Now, there are many countries that struggle with this, and one of the reasons why you have coups d'etats and you have countries that do not have rule of law is their judiciary is not independent. In a recent example, Pakistan has had terrible problems, and lawyers have protested because of the non-political independence of judges and the selective use of law in its enforcement. So Hamilton talks in terms of why we have the judges that we have. They are our referees. They are the people who tell us what is constitutional and what is not constitutional. And they do not necessarily agree on every question. So when you see a story in the newspaper that talks about, oh, Chief Justice is liberal or the Associate Justice is conservative, that's not accurate. That really doesn't help us very much. What did justices do? They look at each question per case. And again, we talk about a case, we talk about the facts of the case, the issue, and the rule of law. And that's what we have to remember. When we're thinking about the law, when we're thinking about what a court will do, ideology, political ideology, is something that's not supposed to be playing into the equation. So the justices don't go into a courtroom, sit down and say, as a liberal judge, or sit down as a conservative judge. Matter of fact, when I was talking to a federal judge recently, and she basically said, I don't remember who appointed me when I'm working. Now, I believe that in her actual work, she's telling the truth. I think that's true. She does not sit down and say, Jimmy Carter appointed me. And she knows, I'm sure she knows that Jimmy Carter appointed her. But what is important for us and what makes the judiciary really an important bulwark in our society is that they are not Judges are not necessarily, and I'm pretty confident about this, are not political. What they are is they're using their legal analysis. Now, of course, it's very difficult to separate one's perspective, but that's what happens when and what we're talking about is this idea of legal analysis. And that's why I had you take a look at those videos on how to think like a lawyer, because it is different than what the media might say it is. Next time, we're going to be talking about a case that describes sort of the rules that the Supreme Court looks at when it decides to issue a certification or hear a case. Thank you for joining me for Alexander Hamilton. Have a great day.